Hello and welcome. We'll be getting started here momentarily. We're just waiting for the viewers to join. So we'll go ahead and get started with the presentation. Thank you so much for taking the time to join. I really appreciate it. Today's topic is a topic that applies to every solo 401k plan, which is how to designate a beneficiary for your solo 401k. So as we go through the slides, please don't hesitate to ask questions in the chat, and we'll field those questions as we go through them. If you're watching this video on a recording, you can ask questions in the comments, and we'll address them within 24 business hours. In the description on YouTube, we will also, if you expand the description to see the full description, we will be adding chapters so you can skip ahead to a specific part if you want to skip ahead and just look at one section of the video. So I would ask you to please like this video. Please subscribe for more videos like this. So again, thank you for your participation and watching. So before we get into the meat of the presentation, I think it's going to be helpful to set the stage to just talk about setting up a solo 401k. So what is a solo 401k? How do you open it, etc.? So a solo 401k is a 401k for a self-employed individual with no full-time W-2 employees. Reasons that someone might want to open a solo 401k would be to make contributions, to be able to take a 401k participant loan, to invest in alternative investments. Those are some of the top reasons that people set up accounts with us, like cryptocurrency or real estate. So you have to have a provider like us who has a plan that will allow you to do the things that you want to do and will support what you want to do. As far as, again, setting the stage of, what is a solo 401k and the process. So when you decide to set up a solo 401k, assuming you're eligible, you're self-employed with no full-time W-2 employees working for you, the process is we have an online application. Within the same day or 24 business hours, we email you a link to our secure portal where you'll have access to the documents that are prepared just for your business. An EIN is obtained for the 401k. So you just need to download and sign the documents, return those documents to us. You can return them back to the portal. Then we would open up an account. We would prepare the paperwork to open up an account at the bank or brokerage of your choice. Of course, we don't have access to that account, only you do. But that would be the next step, to open the account and then fund that account. You could fund that account by rolling over money from a pre-existing former employer plan or a non-Roth IRA. You can't transfer money from a Roth IRA to any type of 401k. Or you could make contributions to the plan from your self-employment income. So that's a very quick summary of the establishment of the solo 401k. So then now we can turn to the beneficiary election form. And really, what is the point of that? So the point is to address the question on this slide. What happens to my solo 401k when I die? So when you die, the distribution of your solo 401k assets is determined by how you complete that beneficiary election form. So for example, you can list whoever you want, or even an entity, as we'll discuss, like a trust. So if you don't list anyone, in other words, if you don't complete that beneficiary election form, then what happens to your solo 401k and the assets in it are governed by the default rules, which means that the assets would first flow to your spouse. And then if you don't have a surviving spouse, your children. And if you don't have any surviving children, then your estate. So what's interesting to note is that the assets that are in a solo 401k are not going to be governed by your will or your living trust. It's not going to be governed by a prenuptial agreement. So it's important to understand that really you have to use that beneficiary election form. It's very important to implement your wishes as far as what happens to the solo 401k assets when you die. So again, I would encourage you, if you have questions as we go through this, don't hesitate to ask the questions in the comments and we'll answer them right here. Or if you're watching on a video recording, you can ask questions in the comments and we'll get back to you within 24 business hours. So we'll keep going. So now let's dig a little deeper in terms of the mechanics of how to complete the beneficiary election form. So for our clients, we email that beneficiary election form that same day or 24 business hours after you sign up. It's part of those establishment documents. So we have, of course, have step-by-step instructions. We can go over it with you over the phone if you have questions. But in simple terms, as you complete the beneficiary election form, you want to follow the steps listed on the slide. So you first have to identify yourself. If there's more than one participant in the plan, each participant completes their own separate form, because really the beneficiary election form is governing what happens to that participant's solo 401k assets. So if you have a husband and a wife, let's say, who are both attorneys and have their own business with no full-time non-owner W-2 employees working for them, such that they could set up a solo 401k, and each participant, the husband and the wife, each have their own account underneath that plan sponsored by their business, each person is going to complete their own beneficiary election form, because each person may not necessarily want their assets to go, they may want their assets to go to different persons or trusts. So you've got to complete it for each participant. Then the participant, once they've identified himself or herself, will identify who the beneficiary is. So you first identify the primary beneficiary, then you identify the contingent beneficiary. So if the primary beneficiary, for example, has passed away, then what's interesting to note is that you can have multiple primary beneficiaries. In that case, though, you want to make sure that you designate or list the share of your solo 401k assets for each beneficiary, and the total must equal 100%. So if you have, say, 3 primary beneficiaries, you could have it 60, 30, 10, or it could be 33%, 33, 33, as long as it all adds up to 100%. Likewise, with a contingent beneficiary, you can have multiple contingent beneficiaries, just list the share and make sure it adds up to 100%. Next, or finally, you want to sign that beneficiary election form. Now, it doesn't have to be notarized necessarily. You don't need a spousal consent necessarily. You would only need that if you are married and someone other than your spouse is named as the sole primary beneficiary. So for example, as we'll go see in a later slide, but if you were to list your trust and you were married and you listed your trust as the primary beneficiary, your living trust, then the form is going to require that it be notarized and that your spouse provide his or her consent. And of course, there's step-by-step instructions with the documents that we send, but that's a good slide to help us understand how it's completed. So again, we emphasize on this slide that the beneficiary election form only needs to be notarized if the participant is married and this participant names someone other than the spouse as the sole primary beneficiary. Can I name my living trust as the beneficiary? That's a very popular question, right? You may be working or have worked with an estate planning advisor, like your estate attorney, with respect to your non-retirement assets, right? Your house, other assets that you may have, right? Just savings accounts, etc. And you may have gone to the trouble of setting up a living trust that governs what happens to those assets. But what's interesting is that the living trust is not going to govern what happens to your 401k assets. As we learned on the prior slide, that is dictated by the beneficiary election form. However, you can name your living trust as the beneficiary. Now, there's a bit of a technical aspect to this, so you want to make sure that you coordinate that with your estate planning advisor, essentially to make sure that the trust that you want to name as the beneficiary has been set up properly to receive those assets. In addition, you want to discuss how your estate planning advisor wants the trust to be listed on the beneficiary election form. Another key point to mention is that if you're married and you're now listing somebody other than your spouse as the primary beneficiary, like in this case, your living trust, now that beneficiary election form is going to need to be notarized, and your spouse is going to have to consent to listing someone other than himself or herself, i.e. the living trust, as the primary beneficiary. Once you pass away, the assets would then transfer to the living trust, and the distribution is going to be governed by the terms of the trust. Next is storing the beneficiary election form. So you want to make sure to safeguard a copy with your other estate documents, of course, provide a copy to your estate planning advisor, provide a copy to us for our records. So it's good to certainly keep the copy with us and your estate planning advisor so that it just facilitates things upon your passing. Now, what about updating or changing the beneficiary election form? So you may wish to update or change your beneficiary election form upon certain life events, right? Let's say you're divorced or you become married, after you've completed the beneficiary election form, you have children, one of the beneficiary dies, you go to the trouble of setting up a living or a family trust. All these things are situations where you might want to revisit that form and then update it. And then, of course, if you do that, you want to replace any prior copies of the form in your records, the records of your estate planning advisor, give us a copy, etc. So we'll stop. Again, if you have questions, please don't hesitate to ask questions in the comments, and we'll address those questions. Otherwise, you can ask questions in the comments if you're watching this on the recording, and we'll get back to you within 24 business hours. So what happens next? So after you pass away, your assets, of course, will transfer to the beneficiary, right? According to that beneficiary election form, the primary, or if the primary is not surviving you, the contingent beneficiary, etc. So if your spouse is the person that inherits your solo 401k, your spouse has certain options with respect to those solo 401k assets. For example, your spouse could transfer the solo 401k assets to their own solo 401k if they're self-employed, or another qualified plan if that plan accepts rollovers. They could transfer to his or her own IRA, they could transfer to a beneficiary IRA, or they could just take a full taxable distribution. So in short, when your spouse inherits your 401k, it's treated as if those assets have all along always been the spouse's assets, as opposed to a scenario where a non-spouse inherits your solo 401k. In that situation, the non-spouse has to transfer the assets to his or her own beneficiary IRA and ultimately must begin taking taxable distributions, generally within 10 years. Or the non-spouse that inherits your solo 401k could also take an immediate full taxable distribution. What's different about the non-spouse is they're not going to be able to take an indirect rollover. That's where they would take the money out and then have 60 days to say, put it into their own retirement account, or transfer to their own IRA. That's got to go to a beneficiary IRA. So I see we've got a question. Thank you so much. So for single people, does they still need the form to be notarized? Great question. It's a very common question. So let's go back to that slide. So does the form need to be notarized? So it only needs to be notarized, first of all, if the participant is married. So if the participant is not married, there's no need for the form to be notarized. You have to be married and choosing someone other than your spouse as the sole primary beneficiary to trigger the notarization and spousal consent requirement. So that brings us to the end of the presentation. So please don't hesitate to ask more questions. We do have more time. You can contact us as well at business@mysolo401k.net. You can call us at 1-800-489-7571. So we appreciate all the participation, and Please like this video. Please subscribe to our channel. We would definitely appreciate that. You get notifications of our weekly webinars. I'm not seeing that we have any more questions. So thank you everyone again, and take care.